We now come to chapter 6 of part 2, which is the adjudicating authority for corporate persons. Section 60 of the Act states that the adjudicating authority in relation to insolvency resolution and liquidation for corporate persons shall be NCLT, having territorial jurisdiction in the place where the registered office of the corporate person is located. Please star that. Without prejudice and notwithstanding anything to the contrary, where a corporate insolvency resolution process or a liquidation proceeding is pending before the NCLT, an application relating to the insolvency resolution or bankruptcy of a personal guarantor of such a corporate debtor shall also be filed with the NCLT only, notwithstanding that it's a personal case which has to go into where? Part 3. So this is an exception. An insolvency resolution process or bankruptcy proceeding of a personal guarantor of a corporate debtor will also come here. Okay? Personal guarantor of a corporate debtor will come to NCLT. Similarly, insolvency resolution process or bankruptcy process of a personal guarantor pending in any court or tribunal shall also come here. Okay? Because there it said pending before NCLT. Then the NCLT shall be vested with all the powers of a DRT for the purpose of subsection 2. Notwithstanding anything contained contrary to the law, NCLT shall have jurisdiction to entertain or dispose of application or proceeding by or against a corporate debtor or corporate person, claim made, including claims by or against any of its subsidiaries situated in India, priorities, question of law, question of facts arising out of or in relation to the insolvency proceedings. 6 says the moratorium period shall be excluded from for the purpose of computation of limitation period. That's it. So it basically says it's NCLT, personal guarantor of a corporate debtor shall be filed before NCLT, where it's pending already, it shall stand transferred to the NCLT. That's the difference between 2 and 3. 4, NCLT shall be vested with the powers of the DRT for this particular purpose. It will have the right of adjudicating an application, claim, priority, law or facts. Limitation period, moratorium period will be excluded. In computing the period of limitation specified by or against a corporate debtor for which an order of moratorium has been made in this part, the period during which such moratorium is specified shall be excluded. Appeals and appellate authority, notwithstanding anything else contained, any appeal against an order of an NCLT shall be made to NCLAT. Within 30 days of the order of NCLT, you have to prefer the application. If the NCLAT is satisfied that sufficient cause exists, they can extend this period by 15 days. And I remember I told you there itself when we did resolution plan, we covered it, but I am going to say it again for matter of emphasis. Where it is an order against a resolution plan which has been approved by NCLT, then you can go in only on the following grounds. 1, insolvency process cost has not been provided for. 2, operational creditor has not been handled as per section 30. The 3rd is compliance with law has not been ensured. 4th, malified intent, material irregularity in the exercise of the powers by an RP during the corporate insolvency period, any other process. Now, they have specified 2 specific aspects for appeals. One is resolution plan. Second is appeal against a liquidation order. You can file only on grounds of material irregularity or fraud in relation to such an order. Please star this. Okay. Appeal to Supreme Court. Any person aggrieved by the decision of the NCLAT can go to the Supreme Court. within a period of 30 days, and if the Supreme Court believes there's a reasonable cause, then they can extend that period by 15 days. Civil court not to have any jurisdiction. No civil court or authority shall have any jurisdiction on any matter on which NCLT or NCLAT has jurisdiction under this code. Section 64, expeditious disposal of applications. In several places in this Act, they specify time limits for application and orders. It's quite possible that NCLT or NCLAT may not be able to comply with such timelines. When they don't comply with such timelines, they shall record the reasons for not doing so in writing. And the chairperson of NCLAT shall extend the time period specified in the Act, but not exceeding 10 days. No injunction shall be granted on any court, tribunal or authority in respect of any action taken or to be taken in pursuance of any power conferred by the NCLT or NCLAT. That's really not relevant to the topic, which is expeditious disposal of applications, but it says you can't go to any other forum. No injunction in a court, tribunal or authority. Anyway, you had one civil court not having jurisdiction. They're saying court, tribunal or authority will not have jurisdiction over something. No injunction. They're specifically talking about injunctions. Okay. With this, we finish up to section 64 of the code, and this is in chapter 6. Okay. Now, we'll talk about 65, 66 and 67. What is 65? If any person, in fact, I think I will handle 65 and 66 in the next segment, along with the next segment or a standalone video, and then actually glide into offences and penalties. So with this, we'll stop here, which is up to section 64 of the code.